Yes, Mr. Goody.
My lords.
That clock says 1 minute to 2, but
Shall I wait?
It is 2.
it is 2. All right, so you can start again.
Okay, thank you. My lords, my lady, I just want to go back to something that was discussed as relatively close to the lunch and adjournment, which was this question of what was said to the judge below and whether there was a concession.
Yes.
I mean, you appreciate, I know that I'm there, so there's a limit to what I can say. But I'm sorry to refer to a document that's not in the bundle, we'll get copies. If you recall, we picked up in paragraph 87 of the judgment.
Yeah.
The judge says, as I said, the claimant accepts the heads of terms from the option agreement are not unlawful or contrary to public policy. In the skeleton argument for permission to appeal, which of course was settled by previous counsel,
Yes.
the following appears, and I'll read it to you and we'll get you the document. It's in the middle of paragraph 9. It is irrelevant whether the heads of terms were legally binding. And then footnote 2, the judge stated in his judgment at paragraph 87, so the bit I've just told you about,
Yeah.
that the applicant conceded that the heads of terms were not legally binding. This is incorrect. The position of the applicant was clearly that it was irrelevant whether the heads of terms were binding. C's position was fully set out in submissions to the excerpt, and the reference is 15 to 32 of the March 2021 document, which I'll go to anyway. So as I say, I don't know what was said below exactly.
That's very odd, because
Well,
if a draft judgment comes out with a concession recorded on the face of it, and you know you didn't make the concession, the first thing you do is write to the judge and say, I didn't make that concession.
I don't
It's not your fault, Mr.
No.
Bewley, but I mean, that's
No,
what I've
well,
expected you to have done.
I don't, you know, as you know, I don't know, can't take that further. What I think is being said though is this, that as I have understood it from my clients and other from reading papers, the position which has been taken is that the strict question of the legal, whether the terms of the contract would be legally binding don't arise, because that would actually arise in a contractual private law case between the parties to the contract. But that is not to, and therefore in that sense that question is irrelevant. But that is not to accept that these terms are acceptable. Indeed, and in a sense we'll see this in a minute when we get to C's complaint, it is at the very heart, not just of the submissions I made to you this morning, but the whole way that C's put its complaint, that those terms are not acceptable. Hollow that out, take that point away, and it's very difficult to see what they're complaining about in a sense. Because they have the tendency to cause the suppression of evidence. That's a whole case, and we're going to see that in a bit of detail in a minute in the complaint.
Well, I'm just wondering how
So
it relates to, this may assist you or it may be neutral. If we just remind ourselves of what Lord Justice Singh said in granting permission.
Just before we do that, can we also look at the grounds of appeal briefly, because there's another related point, and then we'll come to that. So with that point in mind also, so one of the other references you were given this morning is 164, and we talked about it, and I thought it wasn't the paragraph I was looking for, and having now read it properly, it is the paragraph I had in mind to show you. So that's CB 165.
CB 165.
Yeah. Now you'll have read it. I want to take the point so for the present purposes. But this is, if you like, the construction point about the case. Because do you have the paragraph, sorry?
Yeah.
In paragraph 164, Judge says, I'm dealing in passing with the absurd suggestion made by C's that it would follow that manufacturers could lawfully make payments to buy the science persons, Grenfell inquiry, etc., that sort of point. So the judge plainly understood that to be a live point. The sums payable by IPs to landowners under the agreement are not to buy silence. They are for the grant of options and the purchase of property rights. And he goes on. Note those two phrases, buy silence, purchase of property rights. And then again he records what he understood to be the concession. Now with those words in mind, if we can please just turn back to the grounds of appeal now, tab 2, and it's the one I drew attention to.
Yeah.
So it's ground 1A, CB 17. So ground 1A is failing to correctly address or construe the terms of the terms and option agreement, including that the obligations were not to buy, silence, and related only to the acquisition of property rights. So that ground is plainly putting directly in issue paragraph 164 of the judgment, which is what the judge said is being conceded. I think it may be that it was understood, and I'm a little unclear in my own mind about whether it's right or not, but perhaps we just need to turn on this. Whether what the judge concluded was the relevant contractual terms are okay because they don't have the wide effect that of preventing all objections, or they're okay because it's okay for them to have that effect. See what I mean? I think 164, for example, can be taken to suggest the judge thought the former, which is a point about the construction of the construction of the agreement being narrower than I have opened with, effectively.
Yeah.
But if I can put it this way for now, at least, if we stand back from all that, none of that takes away from what I tried to suggest to you is a critical issue. I don't see that there may have been a misunderstanding. I can't say for sure there wasn't an oral concession. I don't know because I wasn't there.
Well, I suppose ultimately the point that matters is that there's no concession now.
There's no concession now. If there was a concession which I'm unclear about, then I suppose I withdraw it. But what I'm inviting you to do is to deal with that point, to deal with the case in the way that I argued it. And to come back to...
Do we not need to look at what Lord Justice Singh said?
Well, I was going to say, to come back to Lord Justice Singh finally
Yeah.
then. So let's do it back to that.
Yeah.
I mean, so that's CB 97.
Yeah.
And the bit I've quoted in my skeleton already read to you, but let's just go back to it. Paragraph 3 of his judgment, Mr. Justice Holgate says the central issue in this case whether the Secretary of State acted unlawfully in dealing with a complaint by the applicant. So it's dealing with the complaint, so we need to see what the complaint is, which we're going to do in a sec. That the interested parties had stifled or neutralised the ability of landowners facing possible compulsory purchase to present objections and to an information about the scheme. That is indeed the central issue, so implicitly at least that's what he's basically granting permission on. And then it's quoting a paragraph, I think, from the skeleton argument.
Yeah.
And then it's where a party with a vested interest, in the middle of that paragraph, with a vested interest in the outcome of the decision, makes secret payments, etc., to prevent them from giving evidence. So there's no possible doubt in my submission. The issue on which Lord Justice Singh saw himself as granting permission was that basic question. And that's the question that I've sought to advance to the court. I hope in line, as I said previously in skeleton, I hope in line with that permission.
I mean, you did start by going to that central issue as Lord Justice Singh described.
And we see that as being what this case is about. I mean, I just make no bones.
Understood. All right.
And in a sense, to make that good, the next task for me to undertake is to show you how the complaint was put. Make a few points about that, and then we just need to look at a few features of the facts. I'm conscious of time.
Yep.
We'll see how we go.
We will only, of course, only ask you necessary questions.
My lord, so can we then go in the supplementary bundle, tab 4, to which is the first complaint of the February complaint. So supplementary bundle 74. Oh, that tab.
74.
74. So this is, as it were, C's initial complaint or first complaint. It's addressed to the EXA, I think. And then on that page, dear Mr. Smith, introduction to the complaint. Complaint is made by C's. And then 2, it concerns efforts being made by SPR to prevent persons who would otherwise have reason to object from opposing the application. And then critically 3, going right to the issue that I've been speaking to you about this morning. The nub of the complaint concerns the fact that in the course of concluding agreements with landowner, SPR is including a clause which makes agreement conditional upon the individual landowner concerned. Then the clause is quoted. Or that clause has the effect of undermining the integrity of the planning process and further the object and effect of this clause is substantially undermine the efforts of those opposing consent. So absolutely no doubt what the complaint is in my submission. That's what this case is all about. There's always been about. And can I ask you to just to note also, and I'll come back to you when we look at the next version of this, but that final sentence of 4, the object and effect of this clause is to substantially undermine the efforts of those opposing consent. So the way the point is being put here, and as we'll see in March, is not, look, it's unfair to landowners, it's unfair to everybody else that landowners are being taken out of the picture. And that's critical because of some observations the judge made, among other things, which I'll take you to in a moment. Then over the page 75, the point is developed slightly in paragraphs 7 through to 9. SBR will no doubt say it's a normal commercial term. Then we say what is normal, which is broadly in line, at any rate, with what happens in different same. And 9, paragraph 9, it cannot be argued to be legitimate, even if commonplace and commercial, for a developer to impose a condition. I won't read that whole thing, you can see it. But I mean, that's my point. That's the point I was asking this morning. And then while we're at it, the then deal, and it's almost as the second bit of the argument which I'm making to you, if we're right that it's an illegitimate thing, what's the impact, why does it matter? So there's a heading, same page, impact upon the planning process, and what's made there. And 13, the examining authority in charge of this process has a duty in law to guarantee respect, etc. So that's perfectly, there's no possible doubt about what the complaint's about. And there's then some hearings, which we have transcripts of, which I'm certainly not going to take you to at tabs 5 and 6. But they include, I think, Therese Coffey MP, among others, turning up, making points which we'll see recorded. And that leads to what gets called the procedural decision of the EXA, tab 7, starting at SB 99.
Yeah.
And that's probably just worth noting. I'm not suggesting it has any great particular weight you should attach to it. SB 100, under the heading hearing, the EXA, under the heading it says the EXA heard sees, position, and then next point about Dr. Coffey appearing. She's expressing the same concern in that paragraph there, second paragraph of the hearing. Any negotiating practices by the applicants might have led to the apprehension in the minds of any affected person they were discouraged from involvement. That's the concern. Then decision is, because the reason they have to make a decision is because they're invited to say this complaint is vexatious, you should chuck it out, and they say no to that. That's on 101. But importantly, in their reasons for that, just draw attention to 2 things. So page 102, and the reasons. It's not in the public interest there should be any enduring apprehension on the part of an infected person that they might be prevented from participating in these examinations to raise their outstanding planning rights objections.
Yeah.
And that's quite striking, because I'm not for a moment saying that's the extra accepting our complaint, but they're certainly seeing the thrust of the point and expressing a concern about it. And they go on to set timetables for submissions and so forth, all of which makes completely clear that what they're intending at this stage is that they were going to make a decision on this, which of course is before lunch is what I said they should be doing. And then it may be that that's done at an early stage, and it wasn't my client's position, I accept it. But it may be that if they did it at a relatively early stage, process still ongoing, that steps can be taken to remedy the problem. Landowners can be told what the true position is or should be, make clear to them that they're not, to use the EXA's words, prevented from participating in these examinations to raise outstanding planning merits objections, and the matter goes forward. And might have been a different decision, might have not, we don't know. And then down the page, just lastly on this page, well, I don't think I need to read it out, but there's a discussion which is perhaps interesting about, and final bullet point about whether the submissions are vexatious frivolous, which I don't need to read out. So that then sets a deadline. Now, please don't ask me to tell you who had what deadline and what stages, but various submissions come in there afterwards. And SPR, I think I should probably just briefly tell you so. Notes. SBR makes a response which is at tab 8. But that I think only really deals with the position of Dr. Gibson. I'm going to just cut him out for a minute and come back to him because he's a sort of slightly self-contained topic. So we park that. And then what we get, though, on the 4th of March from SPR, tab 9.
4th of March 21.
4th of March, I'm so sorry, 2021, tab 9.
Yeah. Go
to please page 132. And I think the only bit that matters is the letter starting at 132. And if you then go within that letter to 134, taking this quickly, I hope that's all right.
Yeah.
Effectively, what you'll see is that in the paragraph, the penultimate and ultimate paragraph on that page, which goes over the page, the position of SPR is that these contracts are perfectly legitimate. They say it accords with the RICS guidance, accords with general practice, no problem, nothing to see here. They're entitled to take that position, I accept that. But that, in a sense, squares up the issue which we say the XR or the due course of the Secretary of State should have resolved. And what they're not saying, principally at any rate, is, well, we're flexible, we'll make exceptions or whatever. They do say, drawing attention to this, SB 135, a couple of sentences in, they refer to terms containing the option agreement which oblige the parties to act in good faith, and they say this: as a result, if a party wishes to continue to raise representations, it would be necessary for there to be an express exclusion contained in the option. And they go on to say that's been offered to Dr. Gibson, as I say, we'll come back to Dr. Gibson.
Yeah.
But there's, on any view, putting the burden on the person affected to raise the need, to raise the problem. Not taking the approach, which I say is the right approach, which is to treat these kind of clauses as exceptional and only to be used if there's a clear justification for doing so. And so the majority of affected, on that approach, the majority of affected persons are going to pick up the agreement. They're not going to know that they've got any scope for negotiation, and that's inevitable. Well, that then leads us on to the more detailed written submission put in by the appellant on the 20th. I think well, let's go to page SB 162, tab 11. And as you can see, there's a heading there. It said, I think the date it was actually submitted might have been the 24th of March, but the date on the document is 8th of March. And that document, 164, contains an executive summary over 2 pages, which is again quite striking in my submission. So SB 164, executive summary. This is a short summary of the main points. And then the complaints is summarised. The complaint concerns the way that SBR used compulsory practice as a go preventing from objecting, etc. So again, no doubt what the complaint is. And then a bit more detail. 165, second line, first full paragraph. The heads obtained concern a series of devastating restrictions. It contains a total prohibition on the landowner objecting, etc. Again, I leave you to read it, but you can see how the points are being put. And then, importantly, developing this aspect perhaps a bit more than the original complaint notes in there already, you've got the heading, the effect of SBR system. The effect of these clauses have been profound. Virtually no landowner has turned up to give evidence to the authority, whether in relation to their own land or in relation to the application more broadly. And this paragraph is quite important. This has meant that on a wide range of really important issues, SBR has managed to prevent relevant evidence coming forward. this covers matters such as, and then there's a long list which I won't read out. And then the next sentence has another list, different kinds of points.
Right, so that was indicating the scope of these objections.
Yeah, the point it's making in my, and this is, I want to now just take you to a passage in the judgment, is that what the concern is. So on the one hand, it's the point that I've already made. It's that the clauses are illegitimate. And then on the other hand, it's the reason that matters is because of the suppression of landowners' evidence and therefore that evidence not being able to support other objectors. But the reason that I want, which again, in a short of the same point is put in the earlier complaint. In other words, the complaint is not about fairness to the landowners. It's about fairness, I suppose, to others who object, or impact on the integrity of the process. But the reason I've slightly laboured that point is because I just want to remind you of a passage in the judgment at this stage, where we say the judge gets that completely wrong. So I can go then to the core bundle. See, the court's still right.
Yeah, no, that's right.
But the reference when you're ready is core bundle.
Are we coming back to this?
Yeah, yes. So please leave that open because
Leave that
this
open.
is a bit of a detour. Sorry.
Right. So paragraph.
Core bundle, page 170, paragraph 190 and 191. And in paragraph 190 is, if you like, definitional. We need to read 190. So 190. The claimant has been granted permission to argue that the Secretary of State failed to consider the alleged practical impact of the IP's conduct, namely the lack of environmental information in the examination from affected persons, thereby distorting the information available to determine the DCO applications. And then he defines it, the practical impact factor. And then he makes some points which, if necessary, I'll come back to about that not being a fact. They're not mandatory factors. But having defined that, paragraph 191 is what I want to get at the moment. But C's complaint alleged unfairness. They never suggested to the panel of the Secretary of State that if the Secretary of State were to reject the allegation of unfairness and decide that there had been no interference with the rights of landowners to a fair hearing, he should nevertheless consider the practical impact factor. But with respect to the judge, that's flat wrong, given the passage I've just shown you in the 25th of March complaint, and indeed elsewhere, but that's a very clear example. The whole of C's complaint was about what the judge has defined as the practical impact factor, the distortion of the process. And either it wasn't at the heart of it or it wasn't really their complaint, that there had been unfairness to landowners. After all, the landowners are the people who've been paid off. So, I mean, whether there's an unfairness to them is a very different question. It's completely clear that the way that C's is always put their case, flat contrary to what the judge says in 191, is that if you permit agreements of this kind with landowners, it happens, but with a subset of those who might otherwise make representations, that distorts the process. It defeats the public interest inquiry, which in this case, the AXA is engaged in. It defeats, and Tasker, the aim of having full information. That's the complaint. So sorry about that diversion.
I'm a bit confused. It's probably entirely my fault. I can well see that a landowner who signs up to one of these might say, I've got this desperately important point I want to make about the Marsh Harrier and the impact that this plan is going to have on the Marsh Harrier. And I can't do it because I've got this gagging clause which is preventing me from raising it. And therefore it's unfair to me because this is a point about which I feel passionately on wildlife and countryside, and it has an overall effect. That I can understand. But gagging him isn't going to stop somebody else who's equally passionate about the Marsh Harrier from raising a point about the Marsh Harrier. So gagging landowner A is not going to affect objector B. So I'm at the moment trying to struggle how if you take away the unfairness to landowner A, you then get a distortion of the process.
Well, Malay, because first landowner A may be the person who knows the most about the impact on the marsh harrier, and or maybe the person who is best placed to articulate that concern, or some variation of that. And secondly, because the marsh harrier, and this is a distinction with private law proceedings, the marsh harrier here doesn't only matter because it matters to landowner A. It matters generally. So someone who would otherwise, so some information which would have come forward, that's a complaint about distortion in a nutshell.
Well,
So
that presupposes that the only person who's got access to that information is landowner
Well, sure,
A.
we don't know. But of course, this isn't a complaint about just one contract. It's a complaint about having contracts like this across the board.
You see, if you've got, I can well understand that if you knock down like Skittles everybody who's got access to certain information so that only they can produce it, and it's material information, I can see the point. But if that information is generally at large and other people can use it, then we're back to the point that my Lord Justice Dingemans made before the short adjournment, which is it doesn't really matter whether you gag landowner A or landowner B because the impact on the process is going to be exactly the same.
Well, my lady, we don't know to take your ladyship's example about the marsh harrier, we don't know, we just don't know, or my client doesn't know, whether the landowners who signed up to these agreements were experts on the marsh harrier or not. Presumably, as a matter of pure statistics, any individual one of them probably not. But we don't know if they're experts on the marsh harrier, and we don't know if they're experts on anyone else.
I'm not sure that helps.
Well,
The fact that there's an ignorance about it, if you were in a position to say, look, there's some really important information that wasn't put before the EA and therefore not put before the Secretary of State because of this gagging clause, then I can see where you're coming from entirely. But you say we don't know, we simply don't know, it's pure speculation.
lady, we say we don't know. We say we can't be in a position to know. That's the effect of the clause, the combined effect of the agreements, the gagging. I don't like the term gagging because it's emotive, but
Sorry, I'm
no. But I mean, it's absolutely the term that's been used previously by my clients. Confidentiality clause.
Yeah.
The combined effect of the non-objection and the confidentiality clause is that they can't tell us whether they would otherwise have made an objection. And I don't want to be overly melodramatic about it. But suppose a criminal court, to take the extreme, probably the most troubling case of all, discovers that a witness has been paid off and then taken the money off to South America. It never knows what evidence that witness would have given, but it's jolly well got to do something. I mean, query whether not for me to say whether it vitiates the trial entirely or what, but it's jolly well got to do something about it. And the fact that it doesn't know exactly what the evidence would have been, it's probably in the nature of the thing that it won't know exactly. It doesn't answer the problem. Now, and that basic principle, and I've taken, as I say, the most sort of dramatic example of a criminal trial, but that basic thought is just as applicable here. And then ally that to the point that this was ultimately, as C's put it, a system or systematic, because these are options agreements. Again, if the evidence was simply that, well, it would be a different case. One troublesome landowner had been invited to and persuaded to sign the agreement like this, but no one else had done so and there was no system, then the court would have probably approached it differently. It might say, well, what was troublesome about it? Why did they want, in that case, to get that particular person to sign the agreement? But it might be able to deal with it in a relatively granular way.
I don't see how it can.
Well, I don't know.
I can't see how it can if it's a point of principle.
Well,
if it's a point of principle and you're saying these types of clauses are objectionable because of the impact that they're likely to have, then it doesn't matter whether you put it in one agreement or 50. They're objectionable.
Well, but I mean, the point that's made against, I mean, on one level, respectfully agree. It's a point. There's a distortion of the process. But the point that's made against me, which I think I'd probably have to deal with to a point, is well, actually, it put in various different ways, is it wouldn't have mattered. It wouldn't have made any difference. That's the point that's against me. And it's put at various stages of the argument. It's put in terms of the highly likely test, and it's put at an early stage. And my answer to that is, well, first of all, we don't know what they would have said, and we can't know. And if anyone should be telling us, it's those who signed the agreements, i.e. SPR, not because they can obviously waive them, qualify them, make investigations and so forth. It's not Cs who are by the very nature of the exercise not in a position to do so. And allied to that on the kind of no difference, putting it very broadly, the no difference point, not necessarily on the section of the senior course out, but however it arises, did it matter? It is, in my respectful submission, pretty important that this is a system. So it's not just the possibility that one landowner who might, but probably didn't have information about marsh harriers, didn't come forward. It's that whatever the number is, 30 or 50 or whatever. And one only has to think that one or two of them had, or might have had, some important evidence to say that the outcome, that could have affected the outcome of the case. And the point I'm going to come on to, but I'll get to it, is that the examining authority in particular was clear that it was a pretty finely balanced decision. So it does matter. That's the answer. I hope that deals with my lady's questions for now. Can I then, again, I'm conscious of time, I'm trying to make judgments that go along about what's most useful. So that's the way C's put its complaint then, and then I think we should perhaps just pick up, let's have one moment. Yeah, I mean, I'm not going to go through them. There are responses, obviously, from SPR to all of this. I'm not going to take time tracking through them. They're making the points which I don't really know. It's not useful for me to go through them. I don't want to take so, and equally, and again, I don't think it's helpful to track through it. There are further submissions by C's, and again, you've got them bundled.
And they're referred to in your scope.
And they're referred to, and exactly. So let me then now turn to the case of Dr. Jimson.
Yeah.
And the significance of Dr. Jimson, and again, I'll take it relatively quickly. Both sides, in a sense, rely on him. So let's just see what the issue is or what's said on either side. Our position is that his case actually shows how strict SPR were being about all of this and how they failed to resolve the problem. What's said against me, looking at almost the same factual matrix, I think we're doing as much dispute about the facts, but actually it shows the opposite. It shows that they were willing to be flexible. Now, we have from him, I'll start with this, a witness statement produced for the High Court, which is at tab 24. And again, I want to take that as mostly read because it's not really efficient for me to read it all now. But can I just pick it up at bundle, so supplementary bundle 403? This is where he starts to deal with the restrictions that he understands are being imposed on him by the way. So paragraph 15, bottom of that page, 403. Shortly after I gave evidence, SPR contacted me directly the first time on 26th January about entering discussion in respect to the case. Coincidentally, on the same day I was contacted by agents on behalf of landowners, copies of an option agreement, and then he sets out the clause that we're all talking about, we've been talking about. And he says, and what he goes on to do is to explain his concerns about the effect of that clause on him. I'm not going to read it, ask you to do so if you haven't already, but not going to read And then he explains that, in effect, the negotiations ensue. And then if you pick it up at paragraph 21, a Microsoft Teams meeting was arranged on 3 February 2021 between myself, a fellow trustee, and Richard Forrest and Kieran Myrna from SPR. During my conversation with them, SPR's position on NDA remained the same. Subsequently, a revised clause for the options agreement was included in the email of 10 February 2021, which contained all the restrictions on giving evidence, but with one exception. And we'll see what the exceptions said. I found this to be remarkable. Even at this point, they were adamant that they should be able to suppress my evidence. This not, and then he sets out the clause, and you can see, but it's the bold text at the bottom of the page. So it's the same clause, but with an exception. Save as the grantor shall have absolute discretion over the withdrawal of all comments pertaining to the impact of the project on groundwater source aquifers. So at this stage, what SPR are willing to do is to permit Dr. Jimson to maintain specifically that objection. But what you'll have seen, and I'll make this good in a different way, is that Dr. Jimson's point is, well, actually, I had a whole range of things I wanted to pursue, and they're only giving me flexibility on this one narrow point. And he refuses to sign the statement. And then and this is critical, he goes on to submit a statement to the EXA. And just before we go to that, I just want to pick up one point in the emails from that period. So his emails are all reproduced, not in their original form, but it's the text of them in tab 3 of the bundle.
3.
Tab 3 of this bundle. You go, please. Again, there's lots of detail. I don't want to spend time on all of it. Go to SB 71.
Yeah.
So this is the way that this concession is being explained to him by his land agent, Samuel Jennings, who's advising him to construct the park. If we look at SPR, if we look at SB 71. So this is Samuel Jennings writing to Dr. Jimson and Christopher. Dear Alexander and Christopher, I have this week been discussing the issue of whether the issue of the water with Scottish Power agents Harry Hyde and Rob Lees, as per the email below. SPR is willing to, and the email has the text we've just seen. SPR is willing to compromise on their absolute bar on objections and amend the terms of the proposed option agreement so that your submissions regarding water can remain not feasible. And Dr. Jimson's response to that is effectively, no, that's not good enough. I want to maintain all my other objections as well.
So are we going to get the top of page 72 in the last paragraph?
Yeah, and then at the top of the page, it said, let me know if you think this halfway house is of any interest. If there are any other elements of your submissions you wish to retain, there may be some more wriggle room, so let me know. But as I say, what Dr. Jimson then does is he says, no, I'm not prepared to compromise all my other objections.
So his responses were?
And his response, in effect, is in the statement which he then submits to the examining.
Did he respond to Mr. Jennings?
He didn't respond to that further that I'm aware of now.
So how was it left then?
So it's left like that. Well, can I show you the statement that he makes?
Right.
Because it reflects his understanding, and this is in my signature. So he makes a statement to the inquiry, which is submitted with C's document of 25th of March. So it's in tab 11 of this bundle.
So it's a statement, we should call it the examination, should we? Really?
Yeah, so it's a Jimson examination statement as opposed to Wilkes.
And that's where?
It starts at 195 of the bundle.
Thank you.
Again, I read it. And
So the
along
date,
the way in that statement.
the date of this is
Oh,
what?
sorry, it's I believe it's the 21st of March. Yeah, SB 204.
Thank you.
SB 20. Sorry, 21st of March.
21st of
See that
March.
date in SB 204. Now, in the statement, he explains the wide range of other matters that he would want to make objections on. And he picks that up from paragraph 23, and I'm not saying I'm going to read it out, but it goes all the way through to paragraph 36 on 202. And then critically in my submission, paragraph 37 is, in a sense, this is how it's left. This is the evidence giving to the inquiry. If I had signed SPR's agreement, all this evidence would have to be withdrawn and these voices silenced. So the critical point in my submission is what is Dr. Jimpson is explaining his understanding of where he has been left to the examining authority, and critically through that to SPR. And he goes on to make some other points in the following paragraphs. But if there was if he was wrong in that, if in fact there was further flexibility, this was the point for SPR to say, no, Dr. Jimpson has misunderstood this. In fact, either he's misunderstood what the effects of the terms of the option agreement are, if that's their position, I don't think it is, or no, we're willing to be flexible and to permit him to maintain these wider objections. So in a sense, to answer my Lord's question about how is it left, in a sense, that is how it's left.
I hesitate to rise, but I know my learned friend wasn't involved, but may not have been familiar with this part of the documentation, but during the course of the examination, there was a precise response to this point made in the written material. It's a supplementary bundle 280. So this is behind tab 15.
Yeah.
These are submissions made deadline 9, paragraph 22.
Whose submissions are these? Doctor?
These are my client submissions
Yeah.
to the examining authority. We make reference to this in our skeleton argument 55.4, but as the latter half of that paragraph 22 makes clear, there was a further discussion between agents on the 11th and 13th of March. It's been made clear the applicants will continue with discussions. The ball is in Dr. Gimson's court as far as any exclusion is concerned. And then it explains that that will be dealt with through the agent. So very much not left without any response.
Right.
So it is. What they don't do is go back to Dr. Jimpson and say, look, actually, we're perfectly willing to let them maintain these.
But they've sent an email to Dr. Jimpson, and he hasn't replied. Is that right or not?
Well, I'll need to.
Why would they to go back to him when he hasn't
Well,
responded?
because his understanding of the Madhu, can I? I'm sorry, I'm not sure I know the answer to that. Can I?
No, that's all right, of course.
So Lord, that's Dr. Jimpson, and then the next real task is to look at the examining authority's decision. And then we're back into the, no, sorry, we're going to be into the core bundle for these purposes.
Their report, you mean?
Their report, because that's all, they never make a further, as it were, procedural decision.
No. Yeah.
So, I should just preface this by saying there are two orders, there's therefore two reports, one on EA1 North and one on EA2. I think for material purposes. So we've got the first of those reports at tab 33 of the core bundle. And it's instructive because, again, it's enormous, so we've only got extracts. Instructive to look at the structure, the effectively the way the report is structured, and we can see that on page CB 566.
Yes.
And you can see it's actually this volume is volume 1, then there's volume 2. The way it's structured, please note, some importance. You go down to chapter 28, the heading is the planning balance, conclusions on the case for development consent, and then you get to the question of compulsory purchase. Now, as a way of structuring the decision, that's fine in itself, because you need to know if you're going to grant development consent before you know whether you need compulsory purchase powers. But it has some implications given the way the issue we're interested in has been dealt with. Because, of course, the whole point that my clients are making is that affected persons may have something to say about the planning balance issues rather than just compulsory purchase issues. That's where the problem about starting their evidence comes in. So with that in mind, if we then go in to see what they say about the planning balance first. So CB 594, there's a heading, overall conclusion on the case for development, and they set out the conclusion, which is the development consent should be granted. I don't read it all out, but can I just draw attention to two paragraphs, 28.4.4. In the excess judgment, the benefits of the proposed development at the national scale, providing highly significant additional renewable energy, etc., are sufficient to outweigh the negative impacts that have been identified in the local construction and operation of the proposed development at the local scale. Quite an important sentence. The local harm that the EXA has identified is substantial and should not be underestimated in its effect. Its mitigation has in certain key respects been found to be only just sufficient on balance. And they reiterate how the benefits do on both parts. And then just to make, in case that leaves you in any doubt, 28.4.8, the final paragraph, they again repeat what their conclusions about planning matters are, but the final sentence is quite important. In the judgment of the examining authority, these matters must tip a finely balanced equation in favour of the decision to grant development consent to the proposal. So I can make effectively 2 points. First, as it says, it's a very close run thing. It's a very finely balanced decision. They're completely clear about that. They're very concerned about the impacts of the onshore development, and that's relevant to thinking about whether some further evidence could have made a difference. And secondly, and I haven't taken you through every page that precedes this, but I don't understand the dispute. Nothing in their report to this stage addresses the C's complaint. So they've reached their conclusion on the planning balance without considering at all whether there's any force in it, whether evidence has been concluded. They just haven't addressed it at all. And as I say, in fact, it was to this issue, not to the compulsory purchase issues, that the point was said to matter by C's. Then, just for good measure, I should show you what they do say about compulsory purchase. So it's over the page, obviously not in the report, full report, but in terms of we've got 599. Sorry, it should say it starts at 597, but for the present purpose, I want you to go to 599. Outstanding objections from affected persons, 29.5.9. At the close of the examination, all matters have been agreed with affected persons except for outstanding objections, which are set out below. Most of the outstanding objections related to rights of access and to the siting of the substation and grid connection works at Friston. Topics not directly relating to objectors' interests have been considered in the relevant chapter. So they're completely clear, again, that insofar as matters of objection that are being raised go to matters other than the narrow question of whether the relevant compulsory power should be granted, that's dealt with elsewhere. Or if it's not dealt with elsewhere, it's not dealt with at all. And then, my Lord, insofar as they deal with the issue, reference, it's better to say, the issue at all, 608, going over 609, but 608, the heading is Dr. Alexander Jimson, Mrs. Elspeth Jimson. They deal with his objection there. Over the page, there's a bullet point, attempts to prevent objection to the application. They're noting it as a point that's out there, as it were. And the final bullet point. The exit notes the objection and specifies that the rights now sought by the would not interfere with the rights of access. Yes.
You're reading from where exactly?
I'm so sorry. So there's a bullet point attempts to prevent objection. So that's there's a list. Effectively, there's a list of objections.
Yeah.
Some of which is case specific. One of them is the general point that we've been talking about. Attempts to prevent objection. And then the final bullet point is them concluding. Notes the objection. That means the overall objection, obviously not the detailed points. Satisfied that the rights now sought by the applicant are not to interfere with the rights of access. So the compulsory acquisition tests are met. So absolutely no doubt that they're not dealing with it other than in the context of compulsory acquisition, to which it effectively has no relevance. And the same point can be made in what seems to me to be the only other point where it's touched on. CB 616 over 617. This is the objection of Tessa, and I don't know how to pronounce it. What check? No one's sure. CB 616, and her objection seems to have included a point about non-disclosure agreements, which I think is a reference to the same point, CB 617. And then the conclusion, same point. So straightforwardly, the examining authority, notwithstanding what it said in its procedural decision, working towards the right approach, just parks it, doesn't deal with it at all, doesn't reach any conclusion, doesn't express any, doesn't give any advice to the Secretary of State about whether there's a risk of matters being suppressed and so on. And I should perhaps show you, just for good measure, 619 on this. I think it might be lying against me. 619, 29 points. So there's a heading human rights. 29.5.125. They set out various fairly generic things, Human Rights Act, Article 6 and so forth. We've considered these matters in relation to the application as amended. We note the applicant followed the statutory procedures in respect to the preparation and examination of the application, conducted proper consultations. Those affected by the proposed project have had various opportunities to make representations and be heard. Consequently, we are satisfied there's been no interference with Article 6 rights. And two points to make about that. Plainly, those who have been made the subject, who've entered into these agreements, have not lost the opportunity to be heard. They've signed away the opportunity. And so that's, it seems to me, just not dealing with that issue. Secondly, of course, the people who have Article 6 rights are those whose land is affected. The Article 6 rights relate to the interference with one's land. They don't relate to the wider objections one may have in terms of the planning process. So again, it's just not dealing with this problem. But I just draw attention to that. So that's the examining authority. Simply enough, we say, it just doesn't deal with it at all. Doesn't address it.
Yeah. So,
So, my lord, then briefly we need to show you the relevant ministerial submissions and then the decision itself. That just completes the exercise.
thank you.
So, in terms of ministerial submissions, that there are actually two ministerial submissions. I think the first is probably not very significant, but I should just mention it. So, tab 26 of the supplementary bundle is a witnessing of James Dawkins, who was the relevant planning case manager, case officer. Responsible for advising the Secretary of State upon receipt of the Ex's report. And as I say, I think this may not be so important, but SB 457, he explains paragraph 9 that there's a information only scoping ministerial submission is sent, and he quotes from it at paragraph 9. And he flags up, in the bit that he quotes, paragraph 12, he flags up his concern. But it doesn't appear that any conclusion is reached by him or anyone else at this stage. So towards the end, one of the action groups has written today is expressing its concerns about how the applicants will use its intended compulsory acquisition terms to secure agreement from landowners, and that non-disclosure agreements have prevented those parties from participating. Officials are considering this issue as it is not recorded in detail in the Ex's report.
I'm so sorry, I just can't find that passage.
Sorry, SB 457.
457, yes.
Paragraph 9 of the statement,
Yeah, I've got that.
and I was reading from just above 2/3 of the way down. So one of the action groups.
Yeah, I'm sorry, I made the mistake of turning the page.
So that submission effectively doesn't take things further forward. There's a further ministerial submission. And Mr. Dawkins tells us that's sent to the Secretary of State with the draft decision letters. So we should look at that. That's at tab, tab 23. And it consists of a relatively high-level overarching submission beginning at SB 379, running through to 385, recommending approval. And then a much more detailed annex, starting at 386, which we don't have all of because it's enormous, which goes into greater detail. And the issue we're concerned with is dealt with at page 388 of this bundle, 6.113 in particular. So this is the advice that officials are giving to the minister, advice seen by the minister. It says as follows. A number of parties made representations to the Secretary of State expressing concern about the applicant's use of NDAs when agreeing to acquire land for construction. That upon entering the agreement for the voluntary acquisition, they would eventually take part in the examination. The suggestion of this prevented the PA from getting a proper understanding of the issues arising from the proposed development. Then a sentence which I have some argument about below. Officials have considered these points and the applicant's response to them. We consider that although some landowners may have felt constrained from taking part in the examination due to agreements entered into with the applicant, that all relevant issues were fully considered in the examination. Now, my submission on the first part of that, officials have considered these points. We consider that although some landowners may have felt constrained from taking part in the examination, he's accepting, at least as a possibility, that landowners who signed the agreements might have had more to say felt constrained from doing so, effectively. In other words, it's accepting as a possibility that signing the agreements had an effect on the representations that were made.
Might have had an effect, but
Might have had.
all relevant issues
Well,
were in fact
sure. So
considered.
then we need to think about what that means. I understand. So then the next bit is all relevant issues were considered. And when we go to the decision letter, that's the phraseology which gets its way into the decision letter, not the first bit. So what's that saying? That's saying, in my submission, that the relevant issues were addressed, not that all of the information that was relevant to those issues was addressed, because obviously the acceptance that some people might not have come forward necessarily implies, in other words, we're saying we've got enough information, that would enable to make us a decision. What we can't know, what it seems to be saying, is we can't know whether other information would have come forward that would have affected that decision.
No, and equally, I suppose it might be said that in this court, and indeed below, it's not possible for you to identify any issues that were not.
No, quite. Well, I mean, it's to some extent the points we've already been.
Yes, but I mean, that's the other side of this.
Yeah.
That if the court were to ask you as the advocate for
I
the
can't say.
appellant, well then, what were the issues that were not fully considered? You say, well, I simply can't say.
I can't say. By definition, I can't say.
Um,
But there's an acceptance that at least there's a possibility that it might have happened, that it might have had an effect.
well, ultimately,
Now, the judge is very, I should say, wasn't going to go to, the judge is very critical of affecting the submission I've made to you. He says, well, that's plain misreading and all that. But I mean, it says what it says. It says, some landowners may have felt constrained to take part.
well, what's the legal test here? Is it a Wednesbury test or is it something else?
Well, you've got to be.
I mean, what I'm getting at, to be less cryptic about it, is this.
Yeah, sure.
The court is confronted with the situation we've just identified. And the court has to make a decision or draw a conclusion on that question.
Yeah.
How does it go about that? Does it adopt a Wednesbury approach? In other words, if the Secretary of State formed the judgment that his officials were right to give him that advice and he accepted it, that it would have to be an irrational decision on his
Well,
part
my lord,
for you to succeed.
I think I make two alternative submissions on that.
Yeah.
So my first alternative submission, my primary submission, I suppose, is that it's not a Wednesbury test, because this is an issue about fairness. The trouble is, there's quite a lot of kind of moving parts. Let me just stop back up a sec.
Is it an
The
issue?
first
about
question is,
fairness?
how does one think about, never mind Wednesbury, on what the court's role is for a minute.
Right.
How does one think about the problem? My submission to you is that when a court or a public body is faced with the possibility that a process like this may have been distorted, the question it needs to ask itself, never mind whether you're asking the same question or reviewing it on Wednesbury grounds for a minute, is whether there's a real risk. If there is a real risk that the process has been distorted, the decision maker who is responsible for that process needs to take action. They can't, as it were, say, well, balance of probabilities is probably okay. Chances are no one would have said anything. Therefore, nothing to see here, I don't need to do anything about it. It needs to take a more strict approach to that. And so my first point is we need to look at the decision itself as well. It's similar to this, but it's not quite the same. Answering the legal question. The question which they should have been asking at this stage is, so first of all, I think they should have asked, is C's right that these contracts are illegitimate, that they have the tendency to distort? But essentially maybe said, well, they bypassed that question and went to the next bit, but then we have to assume that in my favour. So, is there a real risk that evidence has been suppressed or affected? If there is, then the Secretary of State is not in a position to proceed to a decision, at least not in a position to proceed to a decision in favour of SPR without taking further steps. That then brings me to the question my Lord asked, which is what's the role of this court? Well, my primary submission is that the role of this court is the same for these purposes because it's an issue about fairness ultimately. If this court thinks that there's a real risk that the process was distorted, then it will find that the process was unlawful. But if I'm wrong about that and it's a Wednesbury test, then you need to see whether the Secretary of State asked the right questions and so on. And before I make my submissions on that, perhaps we should look at what the Secretary of State actually said. So then we go to the decision. Sorry to dot around, back to the court bundle. Tab 30.
In the,
Sorry, tab 30 supplementary. No, sorry, tab 30 core. I did.
yeah. That's the guidance.
Sorry.
The guidance. Oh, I'm in the wrong bundle. Sorry, I'm still in.
Yes, sorry, it's probably my fault.
No,
Sorry.
no, I'm in the wrong bundle.
Okay.
Now in the right one. Yes.
So what does the Secretary of State say about it? Well, I won't repeat especially the point I made about structure, but if we go straight to the relevant passage, CB 523. I should have said actually, just a note, CB 517 is the heading for the section on compulsory acquisition. So again, I've got the same point about structure. That it's only dealt with in the context of compulsory acquisition, which again is in a fundamental sense missing the point for the reasons I've given. In any event, let's see what was said, CB 523 now.
Yes.
As a heading, the use of disclosure agreements. This issue has been cited by the exit in the objection of Dr. Jimpson and Professor Wojciak, if I'm sorry.
Wojciak.
It's probably Wojciak.
Wojciak.
Fine, I'm happy to be told, I'm delighted.
I think so.
I'm just smiling at my own ignorance. But the EXA provides no further detail in its report. Now, first point, well, and then it says, so, and it's right to say, for the reasons I've given, the examining authority doesn't address it for the reasons I've given. Then it says a submission was made to the Secretary of State by FCs on the 30th of November, setting out detailed concerns. I think that's a reference, by the way, to something sent to the Secretary of State, but never mind about that. I think he's got all the relevant submissions for him. Applicant responded, etc. Then the problem is explained very briefly and at a high level, but so far it goes, I think, accurately. In brief, concerns were raised that the parties entering into agreement with SPR for the voluntary acquisition of land or rights were being required to sign NDAs that prevented those parties from participating in the examination, and that consequently the EXA was not getting a clear picture of the strength of the objections to proposed developments. And then it's dealt with effectively in a single paragraph. The Secretary of State has considered the representation of both SEAS and the applicant carefully due to the important issues they raise, as a sort of acceptance they raise important issues. Say who they're accepting, what they're accepting. And then it just says this: having reviewed the totality of the EXA's report, the Secretary of State considers that all relevant issues were raised and explored in the examination, and that he has the necessary information to enable him to make a decision. Now that, as I say, is reflecting the second bit of the ministerial submission. paragraph I showed you, but not saying anything about the first bit. So in other words, it's not saying, it's not accepting one way or another that there's a problem because landowners may have been dissuaded from coming forwards. It's simply saying all the relevant information,
All the relevant issues.
all the relevant issues, I'm so sorry, and it's important, all the relevant issues are considered.
Well,
And
raised
in a sense, that's right. All the relevant issues, no doubt, were considered.
well, I think we're not reading a statute, obviously, but we need to pay attention to the fact that he uses two verbs. All the relevant issues were raised and explored.
Yes,
But
what he's
there are two things in that, aren't there?
yes, yes. So they're all raised. All the issues are there. So
Do we need to remind ourselves at the outset here that this is, as I understand it, an inquisitorial process, not an adversarial process? Is that is that true, first of all, and is it also
I think
relevant?
it's true.
Yeah.
Yes. My other counsel more experience in attending
I believe that's right, but if I've got
No,
that
I'm pretty
wrong,
sure it's
tell me
right,
I'm
yeah.
wrong.
It is right, my lord, and I can find the reference, but it's recorded in the judgment as such.
Yes.
Yeah.
Yeah. I mean, it's correct. I'm not.
But really, the question for you is that a contextual thing that we need to have in mind?
Well, you should certainly have it in mind because it is part of the context. I mean,
Because the examining
trying to
authority was
yeah.
doing just that. It was examining
yes.
the case on its merits, and it held the initiative as
Yes.
as effectively the small t tribunal in an inquisitorial process.
It's relevant, I suppose, in two ways. One of which is probably a point against me, or could be said to be, and one of which point in my favour. I think the point against me is the one you're, I think, exploring, which is, well, wouldn't it be said that it's for them to decide what they need to look at, and so forth, and that's right. But my answer to that is that just doesn't go to the problem in this case, because you've got to be clear about what the problem is. The problem is that persons who would be expected to come forward, or can be expected to come forward of their own initiative, have been induced not to do so. And unless it takes steps, the examining authority, a fortiori the Secretary of State, are not in a position to know what the effect of that is. And that ties up with two other points. First of all, the other side of the inquisitorial point, which is because they're inquisitorial, you would expect them to take steps in the face of a problem like this. I mean, you would expect, I suppose, even a judge hearing a lien to parties to do so, but you would certainly expect an inquisitorial body to do so, precisely because they're responsible for the evidence that comes to them.
But if they were to call for evidence from certain people, for example, exercising their temptine duty and saying, well, the landowners in this particular part where the onshore works are coming in, we'd expect to hear from them whether they've got any objections. They wouldn't be able to tell them because they signed up to the...
Well, that's the point anyway. So
So
that's why what they need to do is not have a call for evidence. A call for evidence doesn't solve the problem. But what does solve the problem is the thing, or at least one thing that solves the problem, is the thing that I've suggested earlier and before lunch, I think, which is what they do is they say, we're not happy with you signing these agreements, so they deal with that issue, and they tell SPR what it needs to do, which is to make clear one way or another, that those landowners are not prevented. And then it can issue its call for evidence.
So they then have to, what you're saying is they then have to tell the other parties to the agreements that they should tear up their contractual arrangements with the landowners if they want to get...
No, my lady, no. Because this is because the logic of my case is that the agreements were not agreements that the SPR should be entering into. And so it can be said, it's not actually said, I mean, landowners don't have to do anything at all. What SPR has to do is say to the landowners, we're offering you a variation of the agreement. It can be done more or less formally, I don't think it matters very much. one way or another, whereby we make clear that the scope of the non-objection clause is limited. And if they do that, then the landowners are then free, they may not wish to, we don't know, but they're free to come forward if they wish to do so and provide the evidence which might otherwise have been excluded. I don't know if they would have done, maybe none of them would, maybe they would. Maybe all of them, I don't know. We can't know.
May I ask just
Please.
one question on this? I mean, we all know, as a matter of the history of these matters, especially in environmental, one of the reasons for getting the requirement for the developer to carry out a survey and get reports was because otherwise these things might not get picked up. But isn't that in this inquisitorial process sufficient? Because if you look at the reports, the Marsh Harrier, for example, someone's picked it up and the examining authority can run with it.
But my lord, again, I think that's helpful in thinking about the difference between having all the necessary information and the point I'm concerned with, which is the suppression of evidence. So, an examining authority which got a report dealing with Marsh Harriers, as it may be able to say, on the face of this report, we've got enough to be satisfied that there's no problem or the problem can be resolved or whatever. What it doesn't know, however, is whether so it's sufficient in that sense. This is why this is not really a Tameside case. Because a Tameside case is where you as the public body identify a gap in the evidence, in the factual matrix. Whereas it may well be that on the face of the documents before the EXA, there isn't a gap because Marsh Harriers or whoever it is are dealt with. What you don't know is what's perfectly possible, and it happens quite often, is that someone else wouldn't have come forward with a rival report on Marsh Harriers, which would have put it in a different light. That's what's, well, again, we've taken Marsh Harriers, but whatever it is, whatever the issue is, that's what's missing. And to take my lady's example, if the landowner has a great knowledge of or great interest in Marsh Harriers on his land, he may be the best place to deal with that particular thing.
Thank you.
And that's what's missing. And that, I think, if I may say so, does expose, I hope, the difference between being satisfied you have all the necessary information to make a decision, there's no Tameside type gap, and the question of whether material which nevertheless should have come forwards to supplement or contradict or whatever that picture would have put things in a different light.
So you have all relevant information to make the decision, but there may be further relevant information which might better inform you.
Yes, that's it. And then just to circle back around this, and the other point is what the Secretary of State is doing here in that final sentence, and it's all on that sentence. The whole issue is resolved in that sentence of it. Is what's he relying on? He's specifically relying on the EXA report. But the EXA report, as he has correctly pointed out in 26.29, didn't deal with it.
Yeah, I mean, we need to stand away from this particular point, change the facts for a moment. I think.
I don't have that power, but
No, but we have the power. We have the power of imagination.
Yeah, I understood the question. I'm being facetious.
And might it be said that there is always, in an imperfect process, which necessarily all such processes must be, the possibility that somebody who knows everything there is to know about the Marsh Harrier and its habitat on wetland in this part of East Anglia, just chooses not to
it's possible.
bring it forward for whatever reason.
Perfectly true. In fact, it almost certainly happens all the time.
And all the time, there is that imperfection in our decision making, adversarial, inquisitorial, it matters not.
No, absolutely.
And that's just inherent in the whole exercise. And what has happened here, it might be protested against your argument, is that voluntarily some objectors or potential objectors have decided to put themselves into arrangements which effectively makes that decision for them.
Yes.
And that's just the way it is.
Yeah, but that's in a sense that brings us right back to the critical issue in the case.
Yeah.
Because the question is whether that's I mean, obviously it's a general, your lordship is right, so no process is perfect, witnesses don't turn up for other reasons, they don't come up to scratch, they can't be whatever. The question for the court in this case is whether it's legitimate for a party, the main parties in the inquiry process, to engineer a situation which makes it less likely, accepting that those risks are there, that people don't come forward for all sorts of reasons, but to have to pay people so as to stop them coming forward, to make the process less perfect, as it were, less perfect than it is capable of being. Because we all accept, you know, for all sorts of practical reasons, no process will be perfect. That's inevitable. Human beings, whatever. Can we, the Secretary of State, the court, tolerate a situation in which a party, the applicant for the development, commercial party, let's not forget, with deep pockets and all sorts of other advantages in the process, is able to make the risk that relevant information doesn't come forward materially greater? And my answer, well, you know my answer to that, no. Because, and the way to answer that question is to think about the way I put it in relation to the Fulham case. An agreement of this kind will only be capable of being justified if there's a countervailing public interest. And there isn't. I mean, I appreciate I'm making my work with the case today, but I don't understand it to be my opponent's case. That there's a public interest. Let's forget about compulsory purchase for a minute. Let's forget about the acquisition of land rights. There could be a public interest in the general right of developers to buy off objectors and witnesses to planning inquiries, say.
But these clauses only come in the context of compulsory purchase orders, don't they?
Well, they do, but that's my point.
That's the point.
But the logic,
I mean,
well, sure, but
you wouldn't have it outside that.
no, but the logic of, I mean, if you can divorce it from the property right, in a sense, that's my point. If you can divorce it from the property right, why is it limited to compulsory purchase? What principle limits it to compulsory purchase?
Well,
That's a rhetorical question you want for the court to answer me. But
let me make it a real question and answer it, perhaps. It may be submitted. I think actually it is to be submitted that the nature of compulsory acquisition in the planning context, the planning considerations are indivisible from the merits of the acquisition itself. These are not separate and hermetically sealed different things. They are mutually inherent, and therefore there is planning as a dimension of compulsory acquisition. In other words, is there a justification in planning terms for acquiring this land compulsorily, ultimately, if it's not acquired by agreement?
okay,
And the justification put forward, I think this is Chesterfield Properties, isn't it? This
that's
proposition.
okay.
Is that right? That they are inherently or mutually
I mean, I obviously
dependent considerations.
yeah. I mean, I obviously accept that planning considerations are going to come into compulsory purchase. That's obviously right.
Have I got the case
Submission.
right? May not be in the bundle.
We don't have it in the bundle.
I don't think it's in the bundle. No, sorry.
Is it cited in the judgment?
Mr. Justice Holgate deals with that point at 197, but not by citing of authority. It's the last page of the judgment on 172.
Right, if I got the case wrong, forgive me. I thought it was Lord Justice Laws in Chesterfield Properties, but I may be wrong.
Well, can I?
But do answer the point.
Well, I mean, insofar as there's a point about Chesterfield Properties or another authority, it may be that that's a point I need to deal with.
Sure.
That's all right.
No.
But dealing with it as best I can for now. I mean, it's obviously right that compulsory purchase and planning are bound up, because you may make your objection to compulsory purchase on the basis you say, well, there's not a sufficient justification for this need for this development, or i.e. matters that go to planning. But in my submission, that is not in itself a justification for imposing. I mean, my position is, it's not the case that these sorts of agreements are always legitimate in compulsory purchase.
No, no.
It's that obviously the private interest itself can be compromised.
Your case is that they can't be always
Sorry,
legitimate in the
the
context.
my lady, the private, in other words, the property right can be compromised. And for various reasons, both parties have an interest in showing that they were willing to enter into agreements at the right price to compromise the property right, and especially the developer. It's a requirement they're expected to seek to do so if possible. But that doesn't justify imposing a limitation on their planning objection.
No.
Or indeed their compulsory purchase objection, frankly, unless it doesn't justify imposing a restriction on their freestanding planning objection.
Yeah. Understood. Well, you've made that submission very clearly. And in the way in which you formulated it just now,
Yes.
and I wrote down this, whether it's legitimate to engineer a situation to make the process less perfect than it would have been.
Yes.
And that there is here, on the facts here you submitted, no countervailing public
That's the
interest.
point, yeah.
That does seem to be really the crystallisation of your
Yeah.
argument.
Respectfully, that's right.
Yeah.
But it, I mean, in a sense, it's the argument I was making earlier. But the your lordship raised it when I was making a slightly different point about the, because you're also, I think I was also being put to me, well, does the Secretary of State's decision show sufficient attention to these points or deal with it adequately or so forth? And the point I'm making is, what it doesn't deal with, just so we don't lose sight, is the risk that the process was distorted. And there is a striking contrast in my submission. I'm not suggesting this is deliberate or anything, it's just the way these things are, but they're simultaneous as I understand it, between the acceptance in the ministerial submission that there's a risk people may have been dissuaded, I'm not quoting, but be deterred, dissuaded from taking part, and effectively the silence on that point in the decision. But certainly the advice the Secretary of State seems to be getting is, at least, there's a risk that people were dissuaded. That problem is not dealt with by saying that all relevant issues are considered, because it's just a different point. For reasons I think I've explored. I hope I've explored adequately.
Right. Right.
I think I've essentially made my submissions. Can I just have a moment and just see if I had, as it were, a section which I think I've covered off, but I'm just going to briefly tick it off, as it were. So, heads of terms and whether that's an answer, I've made my submissions on. The not legally binding and so forth, I've made my submissions on that. Flexibility doesn't answer. And in particular, because in each case, most importantly, the starting point is landowners are presented with these standard form agreements. And there's no evidence, Dr. Jensen's case aside, we've had suspicions on, that in fact landowners were being told, actually look, it's fine, if you actually have a relevant wider objection you can maintain it. There's no evidence about that.
There is evidence, though, that every single one of them had legal advice.
Yes, that's right. But of course,
So we don't know what they were being told.
well, we don't know what they're being told, but certainly the way the matter is being presented to them is the way that is the general one. That's the point I can make. I mean, who knows what the legal advice would be, not least because they wouldn't have had the benefit of the decision of this court, whatever it turns out to be. So, I don't know what legal advice. It may well be that there's, I mean, I suspect there is, frankly, a sort of understanding amongst property advice in these situations, this sort of thing is legitimate because it's often done, and it may well have expanded out. That's the other point. One can see how a clause that looks legitimate in the context of a pure compulsory purchase process, or indeed where there's a related narrow planning issue relating only to the plan, kind of gets rolled out to this much wider context. It's problematic. And then the other point is, well, there's no, it said against me, there's no evidence would have made a difference, and you have my submissions. I mean, I can only take it so far. It's not, I say, for me to deal with it. I can't deal with it in the context of the highly likely test, which is a respondent's notice point, which I'll deal with in more detail in reply. The burden of proof is on the other side. It's not for me to put forward that evidence. It's for them to satisfy you, actually, that there wasn't a problem, or that it couldn't have made a difference. In a sense, it's a fundamental problem.
Well, it's under the statutory provision, it is in fact a duty upon the court. Once the court considers, as it must, to execute its duty,
Yeah.
whether it is or is not highly likely that the outcome for the claimant would not have been materially different, I think is the formulation. But if it reaches the conclusion that it is highly likely that it would not have been substantially different, then it must.
Yeah, that's right.
Relief.
But that's right. I mean, I'd rather deal with this in detail.
Of course, yes. No, I'm just simply.
But the authority that my opponents have cited is a case called Cover BN, which I'm sure that you'll be taken to. One of the points that's made in that case is that the burden of proof, because the more ordinary situation is defendant effectively raises the point,
Yes, yeah.
and the authority is clear that in that situation it's the defendant or possibly the interested party who bears the burden
Yes,
of proof.
right, yes.
Now, I don't quite know how that kind of plays out in a case where the court raises a very
Well, we don't
motion,
need
but
to.
we're not actually. You haven't.
We don't
raised
need
it,
to
you
go
haven't
there
raised
at the
it,
moment.
raised it.
Yeah.
So, well, I think those are my submissions. Those are my submissions.
Thank you very much.
Yeah,
Mr.
you want the sure. We'll transfer them.
Yeah.
Me too. Thank you.
Yes, Mr. Westminster.
My lords, my lady, I propose to address you in the following structure. First of all, to address you on the proper approach to the factual matrix in this court. Secondly, to identify the statutory framework for the assessment and examination of issues in the context of DCOs and EIA development. That's the process through which the information is gathered and then examined. Then thirdly, to look at the factual background. There are just a few points on the same documents that I want to emphasise, but I'll bear in mind my learned friends already been to those documents.
Yes.
Fourthly, just to consider whether there was any practical impact that's shown by the evidence arising from the agreements. And then fifthly, to address my learned friend's grounds in the structure. He sets them out in his skeleton argument.
Yes.
Before I do that, can I just step back and say why I think my learned friend is wrong? In discussion with my Lord Justice Lindblom this morning, my learned friend arrived at the proposition that the agreements tend to interfere with the administration of justice. And the starting point was that is unlawful unless there's a countervailing public interest point. I say it's key to recognise the nature of the decision that is in question here. That is the determination of an application for development consent. That is an administrative decision to be taken in the public interest. And for that, can I ask your lordships to go to the authorities bundle?
Yeah.
And first of all, tab 10 of which, where's the case of Bushell
Yes.
is included. That's dealing with some motorway schemes.
It's the M40 at Warwick, I think.
Indeed. The facts are not my concern, but at page 297 of the bundle, page 101 of the judgment of Lord Diplock, at the foot of the page between G and H, there's reference to Lord Green and Johnson and Co. And it says, the common case in which a minister's functions are to confirm, modify or reject a scheme prepared and promoted by a local authority, it is pointed out that the minister's ultimate decision is a purely administrative one. And over the page, on page 102, third line, in doing this, he must act fairly as between the promoting authority and the objectors. 4 lines down at B, but when he comes to reach his decision, what he does bears little resemblance to adjudicating on a list between the parties represented at the inquiry. Upon the substantive matter, whether the scheme should be confirmed or not, there is a third party not represented at the inquiry, the general public as a whole, whose interests it is in the minister's duty to treat as paramount. And so the nature of decisions such as these are administrative, as opposed to the determination of issues in the course or the administration of justice. And Alconbury is also included in the authorities bundle at tab 13, and it's paragraphs 74 and 75 of that judgment on 394 that makes the same broad point.
Yeah, this is Lord Buffon.
Your Lordship and Mr. Philpott are very familiar.
Indeed.
So
Paragraph 74 and 75.
74 and 75 on 394, 395 of the bundle. So the situation here is very different from the situation, for example, in the Grenfell inquiry, where the purpose is to get to the truth. Here, the question and issue is the balancing of the merits at heart. And it follows that the allegation of suppression of evidence has to go and have a bearing upon that question of the merits. And as I'll show you, that has been considered by the Secretary of State in the decision letter. It's paragraph 26.31. We'll come to the detail of that. And it has been evaluated by the judge below, who, paragraph 184 of the judgment, concludes that there's nothing in the allegation in this case that makes it an obviously material consideration. And ultimately, when the decision maker is looking at the merits, what he or she has to ask themselves is, do I have sufficient information, judgment for the decision maker on only testable on a Wednesbury basis, or do I need to take further steps to acquaint myself with sufficient information, judgment for the decision maker on a Wednesbury basis? And ultimately, what the appellant says in its skeleton argument, this is its paragraph 88, at the end of this paragraph 88, it says, ultimately it goes to whether the decision maker has full information on material considerations, some of which may themselves be mandatory considerations. Paragraph 88, last part of that paragraph. And ultimately, that is right. Full information to be judged on the Wednesbury basis. And the judge deals with what full means in detail in the judgment at paragraphs 59 and 60, saying that full information in the EIA context means sufficient to meet the requirements of the legislation. And the question of sufficiency is one for the decision maker.
Forgive me, Mr. Westman-Smith. You gave a reference in one of the skeleton arguments. Could you just repeat that?
Of course, it's the appellant skeleton argument, paragraph 88,
Yeah.
last sentence in particular.
That's what I wrote down.
It begins, it goes to whether a decision has full information. Page 23.
Yes, I got it now.
Thank you.
That's fine. I got it down correctly, but I hadn't found the passage. Thank you.
So, underlying all of the analysis, I say it's important to recognise the nature of the decision in question. It's administrative, it goes to the merits, and that opens up the Wednesbury suite of tests, and that's the test that the court needs to be concerned with.
Yes.
So that's an overarching point in response to the submissions of my learned friend. If I can go back to my first sort of heading, which is the approach to be taken by this court to the facts. I know my learned friend in his submissions went straight to the legal points and then he's taken into some of the decision documents. But it's important to note that when the case came before the High Court, there was no single factual narrative. Indeed, it was highly contested. And one can see that illustrated in the witness statement of Mr. Hyde, which is in the supplementary bundle behind tab 27. And what Mr. Hyde does, beginning on page 476 of the supplementary bundle, is he provides a paragraph by paragraph, so to speak, response to firstly Mrs. Gilmore's witness statement. And then starting on page 487, Dr. Ginson's witness statement. And if one looks by way of example on page 485, this is addressing Mrs. Gilmore, her paragraph 63 at the top of the page, that's set out in the first column, the response is the second column, and you'll see it's absolutely and not categorically true that any affected landowners, etc. And in 70, second paragraph of the response, this allegation is not correct. 70A, categorically untrue. The only point I wish to make is not the detail of those points, but there was a factual narrative for the judge to resolve in the High Court. And a point that my learned friend maintains in his skeleton argument, it's his skeleton argument, paragraph 18, is he says that Mr. Philpott's client never refuted any of the central allegations made by Seas. But that's illustrative of a fact that's not correct. And Mr. Holgate, Mr. Justice Holgate deals with that in the judgment at paragraph 125 of the judgment. And one can see, if one has paragraph 125 of the judgment, he's dealing here with the facts and the sequence of submissions during the examination about C's complaint. And at 125, he refers to the submissions on 30th of November 2021, which is tab 20 of the supplementary bundle. And it says, fourth line, after the panel's procedural decision, SPR refused to provide any information, and the position is thus left that the facts that C's have set out are unchallenged by SPR. That's a quote from C's submissions. And he says, it's difficult to see how they could possibly have believed that to be correct. It's plain that the IPs had challenged the analysis and certain factual assertions made by C's insofar as they thought it appropriate to do so. And I won't show you all the instances where that is challenged, but the IP's response on the 31st of January, so this is when the decision was before the Secretary of State, is illustrative of the point. And that's in tab 22 of the supplementary bundle. And on page 374, at paragraph 11, the interested party, page 374, paragraph 11, the interested party says, C's characterisation of the appellant's negotiations is wholly inaccurate and misleading, points to the fact that the landowners were properly represented, had independent land agents and solicitors, and the interested party had paid for them. And then over the page on 377, paragraphs 18 to 23, I won't take you to the detail of that, but that's dealing with specific allegations that have been raised. So there was a highly contested factual matrix. And it was for that reason that the judge took some time and care to grapple with the facts. And if I could take your lordships to the judgment and just see the approach of the judge, so paragraph 28. So the claimant said to the judge, this is in the quote in 28, third line, the court merely needs to proceed upon the basis that a serious complaint was made about the evidence collection process. And the judge underneath does not accept that. He says, fourth line, it's very much a matter for the court to consider and determine whether a serious complaint was made, which is legally capable of justifying the imposition of an obligation on the Secretary of State to investigate. And then at 29, I don't think I need to take you there, but or maybe I'll just highlight one sentence Fourth line, it's for the court to determine the facts relevant to the alleged legal flaw. And then over the page to paragraph 34, please. Paragraph 37, I meant to say, paragraph 37. The judge observes that Mr. Wolfe didn't develop his legal arguments at any length, preferring to rely upon his analysis of the facts. For that reason, it's been necessary for me to review the factual material in some detail. So, contested factual matrix, the judge recognises that and expressly grapples with it, and your lordships have read the judgment, does so in some detail and with some care. And my Lord Justice Singh, in granting permission, I won't take you there, but it's tab 7 of the core bundle, page 97, and it's paragraph 3, where he expressly identifies the danger of it becoming an argument on the facts and said permission wasn't being granted in relation to findings of facts. And then your lordships will be familiar with the approach of this court in relation to findings of facts. We've got the Smeek Properties authority in the authorities bundle at at tab 16, which makes the point that this court is generally limited to a review of the decision of the lower court. And that applies here.
Do we need to look at that?
We can go there, right, Lord. So tab 16 starts at page 500, but the relevant paragraphs are at page 507 of the bundle. And at paragraph 26, it sets out CPR part 5211, making the point appeals limited to review unless, and there's no unless applicable here, and I don't think it's suggested by any party that there is. And then the relevant passages to read are really 27 through to 30. But if I could just highlight at 27, third line, it means, this is limited to review, means that the task for this court in looking to see whether the judge was wrong, so that the appeal should be allowed, is to ask whether the judge had legitimate and proper grounds for reaching the decision she did, rather than simply for this court to approach the matter completely afresh and make up its own mind without regard to what the judge said. And at paragraph 28, there's an argument, well, in these particular circumstances, the court is as well positioned as the judge below. And at 29, what the court then says is that that's not correct. Where an appeal is to proceed like this one by way of a review of the judgment below rather than rehearing, it would often be appropriate for this court to give weight to the assessment of the facts made by the judge below, even where that assessment has been made on the basis of written evidence, which is also available to this court. And then the weight will vary. And at 30, the weight may be enhanced in certain circumstances, for example, a judge of particular experience. I'll allow your lordships to read that paragraph, but my submission is that applies with force here. It's a fact-heavy case. There was a 2-day judicial review in front of one of the most experienced planning judges. He grappled with the facts in great detail, and he expressly did so because of the way the appellant claimant then had put its case.
Do you contend there's any difference between public law and civil law generally, where Volpe makes it clear we should leave findings of fact alone unless they're inconsistent with an uncontroverted fact or irrational or internally inconsistent?
Not for these purposes. And just looking, while we have the authorities bundle, can I just draw your attention, again, your lordships will be familiar with it, but to the Phage UK case, which is in tab 15.
Greek yogurt case.
Greek yogurt case. Yes. And it's Mrs. Justice Lewis and well, my lady
You can
knows.
take it that we all know
Yes,
about
exactly.
Favour and Tribunals.
Well, I'm grateful. That's the paragraph, the island topic. So my submission is on that basis. There's no reason to go behind any of the factual findings of the judge in this case. And my learned friend hasn't expressly asked you to do so. But one thing that is important is that his case springs from still the C's view of the facts. And we said that's inappropriate in this court, having had a detailed judgment below.
Is it really his characterisation of the facts? I mean, what he puts Mr. Justice Holgate's findings in what you would consider to be contentious terms, but the findings are the findings.
Yeah, my point is simply there is no basis on which to go behind the findings of the judge below. Can I then deal with my second heading, which is the statutory framework in which information is gathered and decisions made? And this in part goes to my Lord Justice Dingemans' point about land ownership. There is a legislative structure in place that allows for the procurement of information and its examination that applies irrespective of land ownership. I can take this shortly and deal with it by reference to the judgment. The judge deals with this paragraph 40 on. Under the framework, statutory framework and legal principles. And may I make one point that arises from my learned friend's submissions, and it's an important point, but we don't have the relevant provision, but your lordships will be familiar with it. Section 104(2) of the Planning Act 2008 tells a decision maker what they must take into account. And that includes matters that they find both important and relevant. And that is to be borne in mind when one considers objections, whether or not they are withdrawn during the examination process. Because if an objection is made and covers a matter that the examining authority thinks is important and relevant, they will be seized as a matter of statute of that. It is not a point that attaches to the individual landowner or objector. It doesn't disappear with the withdrawal of an objection. It is something they have to take into account. So that's section 104(2) of the Planning Act 2008, not in the authorities, but we can provide a copy if your lordship require.
Well, you've given us the reference to it, and I'm sure we can find it.
Your Lordship's familiar with it. Turning to page 136 of the bundle, paragraph 42 of the judgment. These provisions referred to in the judgment here are all in the authorities bundle, but I think it's a more efficient way of addressing the points to look at the judgment. Section 74 of the 2008 sets out the functions of the EXA, the examining authority. It's to examine the application, to report on it, and make recommendations. And as the judge observes, and it goes to the point my Lord Justice Nimblom made earlier, paragraph 43 of the judgment, the examination process is inquisitorial, not adversarial, and the halite energy is the source for that. And that takes one back to the Bushell point. One is not adjudicating on a lis inter partes. It is a decision in the public interest on the overarching planning merits. The judge then at 47 deals with the infrastructure planning examination procedure rules, which he calls the 2010 rules. They're in tab 10 of the authorities bundle. And this shows the powers available to the panel. So 10.6 require a person to submit written representations to respond to questions from the panel or to provide further information. Rule 17, a broad power to require further information. And then Rule 16 at paragraph 48, the ability to carry out site inspections. And I'll come back to the information received and move on to the environmental impact regulations, which he deals with at paragraph 52. And your lordships will be familiar with this territory, so and you've read the judgment, but the point is there's a prohibition from making an order granting development consent unless a process has been through. That includes the provision of the environmental statement. And over at page 50, paragraph 53 and 54, the relevant regulations as to the contents of that statement are set out, and it's prescriptive. And I just highlight that at the foot of page 138, quoting regulation 14 subsection 4, the legislation states, in order to ensure the completeness and quality of the environmental statement, the applicant must ensure the environmental statement is prepared by competent experts. So expertise fed into it. And then at 54, in terms of regulations 5, one can see what it must cover. And what it must cover is a broad remit of environmental issues and topics. It's back to 52, it's subject to statutory consultation, that's regulation 16 in the middle of the paragraph. And then regulation 21 requires the Secretary of State to examine the information. And then importantly, under regulation 21.3, to reach a reasoned conclusion on the significant effects of the development on the environment and to integrate that into his or her decision. So it's a highly prescribed process that requires certain topics to be covered by experts, and then ultimately its adequacy, paragraph 57, is a matter of judgment, going back to Blewett, well established, challengeable only on the Wednesbury basis. And I just observe I passed over 55 and 56, but that refers to the powers of both the Secretary of State and the examining authority to require further information if they come to the view that it is required. So there's a very carefully prescribed system to ensure that there's enough information before the decision maker, and then a decision for the decision maker to make as to whether there is or not. May I then go to my third heading, which is the facts? And I will go to some documents my learned friend went to, but it is to draw different points of emphasis, not repeat matters. And by going to the underlying documents, the examining authority's report and the decision letter, it sets the context as to whether or not there was sufficient information before the decision maker, and whether or not parties were and did object. Because one of the striking things about my learned friend's case is that he goes straight to the option agreements. Well, none were signed during the course of the examination. 2 were signed a matter of 3 weeks before the Secretary of State's decision, but that's never been suggested to be material, well after the evidence gathering stage. And it also overlooks the fact that there were 39 landowners who maintained their relevant representations and objections till the end of the examination process. And I'll show you that that's the case. But this case can't be decided in a vacuum. It does need to be apply principles to the facts. And the facts are there were no agreements in place, only heads of terms, and we'll come to whether those were binding or not. Can I begin by taking your lordships to the examining authorities report, which is in the core bundle, tab 33. My learned friend showed you the table of contents on page 566, which just shows the scope of the issues dealt with. Can I take you to page 578? The examination process is a mixed process of written submissions, principally written process, hearings, site visits, written questions. And the site visits, you can see the heading 578, are set out at 1.4.28 and over the page. And in short, there were some 16 by my calculation site visits. Underneath that, the hearing process. This was not a light touch examination. There were some 17 issue specific hearings. 4 were on the draft DCO, and one can see that at 1.4.33. And then 13 others at 1.434 dealing with particular topics, and you can see the topics dealt with. At 1.435, 3 compulsory acquisition hearings. And then also, and this is important in the context, there were not 1, but 7 open floor hearings, 1.4.37. Open floor hearings being what it says on the tin, where members of the public can come and express their views. Over the page at 581, under relevant representations, which is the first stage of written submissions, objections, there were some 879 relevant representations. So in terms of public participation, that is what you are seeing recorded here. And then at the foot of the page, local impact reports, something that section 104.2 requires the decision maker to take into account, but a local impact report produced jointly at 1446 by East Suffolk Council and the Suffolk County Council. Then you can see there's this whole suite of statements of common ground that indicate the range of parties involved beyond individuals and their nature. For example, it includes the Environment Agency and Natural England. And again, that is a picture of wide engagement in the process. And then over the page, just final few points, there's written questions. There were 3 rounds of written questions at 1.450.
Who are those from?
Those are from the EXA. So the EXA, one of the sort of set pieces of the process is they issue written questions, normally a horrible number, which are addressed probably in the main to the applicant, but if there's a particular question for Natural England or a particular objector, that will be identified and addressed to them. And then at 1.451, requests for further information. So this was not a process where the examining authority just sat back and said, well, that's the information, that will do me. That they actually went out on 7 occasions, 6 occasions, apologies, asked for further information. And then lastly, in this part of the report at 1.456, it records that 3 representations were withdrawn, and they were all statutory undertakers, the Cadent Gas, Network Rail, and EDF Energy Nuclear Generation. And so what the judge says, and I adopt his wording at paragraph 51 of the judgment, is that on any view, this was a process of collecting and analysing information on a massive scale, and which fed into the very substantial report produced for the Secretary of State and his department. Turning then to the second volume of the report, I know, friends, taking you to the planning balance. Can I take you to page 598 of the bundle?
Sorry, can I just check your reference? You said paragraph 51, the judge said this was information gathering on a massive scale.
Yes. Should I?
I may have missed it, but I think he's just addressing the law there.
Apologies, it's 50. It's the last sentence
Ah.
of 50.
No, that's fine. But
No,
that's
it's
fine.
entirely-
Fine.
It was my reference was
Okay,
wrong.
right, yeah, thank you. Sorry to interrupt.
So, in the second volume, page 598 of the bundle, at paragraph 29.5.4, the EXA says there are over 800 relevant reps made, of which over 40 relate to compulsory acquisitions and TP as temporary possession issues, and one further written representation related to those issues. It's important just to place that in context and the number of outstanding objections from landowners or affected parties at the end of the process. And the judge records at paragraph 5 of the judgment that the orders also authorise compulsory acquisition of land, in particular land needed for onshore works, from 55 different owners. So we're not in a world where landowners did not come forward. We're in a world where 40 out of 55 did. And over the page on page 599,
Sorry, just before we leave that point, do we know whether those were supportive representations or not?
we know they are, I can tell you 39 of them. 39 were objections. And I can show you that from the next page.
Thank you.
Page 599, outstanding objections from affected persons. And your lordships will see there's boxes of greyed out text, and each one of those boxes has above it a number, an objection number, and the identity of the party, as well as the number of their relevant representation. And those objections are dealt with over the next 18 or so pages. And if one turns at page up to CB 617, at the foot of the page, you can see 39, the Warden's Trust.
So it was a Sizewell estate partnership that was running with the sort of offshore ring main point.
Yes, well, I think a number of objections did, and my learned friend made the point to you that at paragraph 29.510 on page 599, it said most of the outstanding objections related to rights of access and to siting of the substation and grid connection works at Friston, topics not relating directly to the objector's interests have been considered in the relevant chapter of this report. So what that's telling you is they were maintaining objections as to wider planning issues that go beyond just their interest in the land that's dealt with at this part of the...
Can you just give me that reference again?
Yes, it's paragraph 29.5.10
Thank you very much.
on page 599.
Thank you.
And throughout the process, there was a schedule kept by the interested party as to where matters stood with each of the compulsory acquisition and temporary possession objectors. And it was updated at each deadline as the examination proceeded. And the final one is included in tab 18 of the supplementary bundle, but there's no need to turn that up. My learned friend pointed out that Dr. Gimson, for his mother, dealt with on page 608 of the bundle, and in particular over the page at 609 there's reference to his concern. It's the third bullet up from the bottom of the list of bullets, about attempts to prevent objection to the application. And similarly, Tessa Wojciech is on page 616, and her outstanding objections at the foot of page 617 include non-disclosure agreements. And then over the page, matters, so 621, matters that were outstanding at the end of the examination. And you can see at 29.5.135, at the end of the examination, representations from the following 39 affected persons had not been withdrawn. And then Mrs. Gimson is dealt with again on page 628. And again, the penultimate bullet point on the page is dealing with the option agreements and its effect. And I'll come back to it when I deal with the options agreements, but I'll just point forward that my position is that the judge fairly records the concession below that the agreements were not unlawful. What was in issue was their effect, was there a chilling effect because of it. But I'll deal with their legality anyway because it's squarely before this court. And then over the page at 629, Warden's Trust, and underneath the first suite of bullets, lack of meaningful engagement and trust, and under Wojciech, penultimate bullet is non-disclosure agreement. And in the conclusions, 29.6, over the page, the human rights conclusion is there's been no interference with Article 6 rights. And my learned friend says, well, that doesn't address whether people actually felt constrained from turning up and making their points. But my response to that is they had the opportunity, and it's for them to determine whether or not they exercise that opportunity. One way they may decide not to is by simply not engaging with the process. Another way is to enter into an agreement, a term of which is not to object, and there's no real difference in that. The next point is, well, it is said against me, but that doesn't deal with all the issues. But this is a finding of fairness in the context of compulsory purchase. And as my Lord Justice Lindblom indicated earlier, compulsory purchase is inextricably linked to wider planning matters. not least because the question at the heart of compulsory purchase is there a compelling case in the public interests that incorporates the planning balance? You can't divorce the one from the other. And of course, thirdly, if one does have someone, a landowner, signing an agreement and compromising their ability to participate in the process from there on in, that has to be understood in the light of the agreement in the context of compulsory purchase, where that is the compelling case. And if they accept that for whatever reason they do, it's difficult to see how a planning point survives that. So the factual position, coming back to the facts, the factual position, as we've seen from the EXA's report, is that there were 39 objections that related to landowners from affected parties that hadn't been withdrawn by the end of the examination. My learned friend in his skeleton argument, it's page 10. And it's footnote 11 right at the bottom of page 10. He says the judge said that 39 landowners opposed and did not withdraw. That's incorrect. There's no analysis of the content, etc. And I just say, point your lordships back to the analysis of the EXA, in particular under the heading outstanding objections, and that suggestion in footnote 11 flies in the face of the EXA's report.
Sorry, is this footnote 11 to the skeleton?
To the skeleton, the appellant's skeleton, it should be page 10.
Yeah. That's 39 out of the 55 landowners that we know.
Precisely.
Oh, it's page 10 of the skeleton, sorry, page 28 of the bundle.
Then I think with that I can go to the decision making by the Secretary of State.
Right, let's just pause for a second. This is still part of your factual background.
It is, but it is a juncture. So if your lordship wishes to pause there, that is a convenient place for my.
I suspect that once we get into that, it's going to take longer than 5 minutes or so.
It probably will, my lord.
So I think we should call it a day there. We should be still, I think, on course to conclude submissions, including the reply by midday, the normal midday adjournment time.
I would hope so, my lord. That gives me an hour. Well, a friend an hour and maybe half an hour for a reply, if that's.
Yeah, I mean on that basis, I would have thought that's doable.
Yeah. So I will do my best to limit
But
myself.
we're not imposing deadlines or guillotines or anything like that. But I haven't given up on the possibility of that happening. All right, then 10:30 in the morning. Thank you all very much.
Well, I was going to say. So My clerk sent me an email saying the listing's here.
Right, tomorrow.